Political dignitary up here in this empty chair? No. This is a tool for me. If you've ever heard me speak before, they put me on just before lunch. How many people have driven from Jackson, Tennessee in here? I know there are several of you, because a bunch of you. I know how low on blood sugar you are, because I've driven from almost the Kentucky line to get here. It's good to be with all of you volunteers today. My name is Jim Hawkins, and I've been asked to speak on the topic that I call Expungement 101. Vicki, it's the sense that this is a learning opportunity. Vicki came, I think, to my class last year in Sumner County. This is the new improved version, Vicki, so you'll get more CLE today. Who does not have a handout? If Laura and them have done their job, everyone will have a handout. If anyone feels so moved, they gave me additional copies to give out to you to take home. For Laura will sign her name on them. Laura, thank you for handing out a copy to everybody. I was just giving you credit. Could we have a credit for Laura McKenzie, who's been a big organizer here? It was Laura who stayed up on top of all the speakers, making sure they all got their handouts in, making sure they all had a map on how to get here, and making sure we had a bus ride two ways. I appreciate that. I want to also salute Chai and Dawn for their Immigration in 45 Minutes, which was a sweeping and semi-historical panoply of how federal law interacts here in Tennessee. In honor of them, I want to first touch on, I think we have at least one Supreme Court justice in the room. Do we have a justice still here? Yes, thank you. And in fact, do we have Justice Clark here? Is that Justice Clark hiding in the dimmer light? Okay. She was one of 5 Supreme Court justices who signed a unanimous opinion in a case involving a Mexican immigrant who had been married to a U.S. citizen for nearly 10 years before he had an error in judgment in 2007. For those in the back of the room, I'm quickly bridging immigration and expungement. There's purpose in this. It's not in your handout in case you're looking for it. In your handout, you'll see references to Governor Andrew Johnson from 1853 and Marcel Proust from 1913. This is from Justice Holder in 2010. There was a case in which a Mexican immigrant, been here nearly 10 years, had an error of judgment and was arrested, pleaded guilty in 2007 to the lesser charge of patronizing a prostitute in exchange for judicial diversion. How many people do not regularly practice criminal law in here? Excellent. You are my target audience. As Vicki, where'd Vicki Trawl go? Our Vicki Trawl, a Sumner County, and as she knows, this chair is here because I use a tool with embedded caffeine and protein to help you stay alert until 12 o'clock. Yes, there's no such thing as an interruption in this next 43 minutes. If you have a question, if you have a comment, you will be rewarded. And if you are and Zale, if you get 2 right, or ask me 2 questions, I'm going to start going to your peers. So proximity, your table may win from your largesse. But speaking of largesse, that's what the Tennessee Supreme Court called judicial diversion. They said it is a scheme of legislative largesse. In other words, it's an almost get out of jail free. It's a get up to the brink of jail, go through probation, satisfy all your probation, pay all your costs, and then have that charge wiped off your record like a conditional plea. Mr. Rodriguez, Jose Rodriguez, pled guilty 2007, finished his judicial diversion, flying colors in 2010, and then found himself suddenly at odds with the Immigration Service because of his having been charged with a crime. He said, wait a minute, I should have gotten the benefit of the Post-Conviction Procedure Act that was passed by Tennessee legislature. And he pled guilty, he finished his post-judicial diversion in 2010. The legislature then passed the Post-Conviction Procedure Act, took effect in September 2010. That was a new law that made it a legal requirement for immigrants, lawyers, to inform their clients that their immigration statuses could be harmed if they chose to plead guilty to crimes. He said, hey, this law wasn't around when I was encouraged to plead guilty so I could get judicial diversion. I should have had the benefit of it. It went up to the Court of Appeals. Court of Appeals said, sorry, this is a technical conviction requires an entry of judgment. You never got that because you had a judicial diversion, so you don't benefit from the Post-Conviction Procedure Act because you did not have a conviction. Even though he had an expungement, even though it was wiped clear off his records, even though by the time he got to the Court of Appeals, he was, by the famous Serve Pro logo, it was as if it never happened, except there was still a record of it with immigration. Went up to the Court of Appeals. They said, sorry, too bad. Went up to the Supreme Court, and they said a guilty plea expunged after a successful expungement is simply not a conviction that triggers protection. As much as we, the Supreme Court, might like to do otherwise, we have to do what the legislature says, follow the plain meaning. Can I get an amen from Justice Clark? I'm not getting an amen, but because, she did. Thank you. Here goes the first kiss, and I'm not sucking up to Justice Clark. I'm quoting her without permission, so I thought it's only fair. So that case came down. So what's the first takeaway practice point? If you have a client who is not a U.S. citizen, could be married to a U.S. citizen, as Mr. Rodriguez was, and they're pleading guilty before they plead guilty, even to something that could be expunged or will be expunged, you have to inform them of their rights. And I'll take it one step further. I used to be the managing attorney for Legal Aid Society up in Gallatin. We had a housing client who came to us whose private attorney told them to plead guilty to a simple trespassing problem in order to do away with a fight between them and a neighbor. They pled guilty and got full probation and instantly were evicted from their public housing. They had not been told by their attorney that the act of pleading guilty, even to a no jail time charge, would damage and impair their public housing status. So be careful as you're working with criminal cases for persons who could be damaged by immigration or by receipt of benefits, where a clean record is a key. Cover sheet, Expungement 101. I'm reminded of a day a few years ago. It was a day like today, a day when I was in an audience with John J. Hooker. I don't remember who the speaker was. It could have been Harris Gilbert. It could have been someone else. But that speaker said, truly, today is a day when the sun shines brighter, the birds sing more sweetly, and the irises bloom with richer colors. For last night, the Tennessee legislature adjourned. We had such a day of beautiful weather last Thursday, the day after the legislature adjourned on Wednesday. Why do I mention that? Because I've been tracking the legislature in 8 different expungement laws all session to see what's going to happen, to make sure I could bring you up-to-date information. There's one bill that's still going up to Governor Haslam. It hadn't been signed into law yet. It will allow the crime of drug fraud to be added to the list. But right now, it's not there, so that's just a little secret. If you're here, you get to know about drug fraud ahead of the rest of your fellow members of the bar. Today, we're going to talk about how the new expungement law works. And when we call it the new expungement law, it was passed in 2012, but really, it is still so unknown and so ununderstood that it is worth looking into. I'm also going to talk about a couple of civil expungements. That'll be lagniappes for those of you who don't do a lot of criminal law. And we'll talk about a brand new partial expungement law that was just passed a few days ago and was signed by the governor. It takes effect July 1st. So instead of going big screen, I'm going big paper. We're going to page 1. Here we go. Page 1. I'm not just going to read, but I'm going to touch on some key points. Over and over in Tennessee law, you'll see the term expunction rather than expungement. Yes, that's the legislature's term. They use it, but whenever they're talking about it, they always say expungement, and our judges say expungement. And if you look in Black's Law Dictionary, they say the term expungement is preferred. So that's why my heading is Expungement 101 instead of... I got it right here from the head table. Thank you, sir. Is it Dave?
David.
David.
Yes.
Thank you, David. Very good. Now, David is from Nashville. Is that true, Nashville? And how many here are from Nashville? Okay, I am from the small town of Gallatin, but our former state historian, Walter Durham, once said in another small group in which I happen to be present, and this time I do remember who said it was Walter Durham. Walter Durham traveled to England amazing student of history, Walter Durham, was shown this international encyclopedia and almanac of geography that was published in the early 1800s about the United States. And his British friend proudly opened it and showed him showed him the entry for Nashville, Tennessee. It said, Nashville, Tennessee, the capital city of the state of Tennessee, located 26 miles downstream of the Cumberland River from Gallatin, Tennessee. I always liked it, and Walter Durham always liked it, that Nashville was defined in its downstream proximity to Gallatin. So I bring you upstream wishes from Gallatin. Let's continue. David Rabin wrote an amazing article in the Tennessee Bar Journal back in 2009, before the new expungement law passed. And I've read through it 5 or 6 times. I just want to point out an amazing quote that bears reading out loud. For years, expungement has conveyed the correlation or the connotation that there's a stain, a shadow, a penumbra that goes with criminal convictions. In fact, back in 1853, our former Governor Andrew Johnson opposed the practice of teaching inmates stonemasonry, which would enable, quote, the criminals to engrave names upon the tombs of the departed. Governor Johnson said that convicted felons must be excluded from those persons having charge of the cemeteries. If it is degrading to be associated with a felon while we are living, it must be more so to be associated with them after we are dead. Nice job, David Rabin. But I'm going to move from David Rabin to Marcel Proust, because the Tennessee legislature did pass a new law in 2012. Perhaps they were inspired by the words of Proust, who famously wrote in his first volume of Remembrance, "There is no man, however wise," and I would add that there is no woman, however wise, who has not at some period of his or her youth said things or lived in a way the consciousness of which is so unpleasant to him or her in later life that he would gladly, if he could, expunge it from his memory. That may be of what inspired the legislature, but more likely it was the fiscal note. The legislature thought they were going to make thousands and thousands of dollars. I've gone back and researched the fiscal note. They thought they would ka-ching, ka-ching. Money would go to the district attorneys, money would go to the public defenders, money would go to the clerks. And in the first year, we had a grand total of 17 applicants. Why such a high hurdle under the new expungement law? I'm going to tell you. Let's go to page 2. The new expungement law is the expungement law that brings in the bucks. What bucks does it bring in? It might be $350. I told some of you at the Tennessee Alliance for Legal Services conference a year and a half ago. It might be $450. Which was correct? The answer then was both. Since then, the legislature has passed a special law. The law passed in 2012 said that the clerks have to charge the $350 fee, and then it gets divvied out. They get to keep $10. The clerks were upset. They got a special law passed in 2014 that says, hey, we get to charge $100 for having to handle all this stuff. So now it is a grand total of $450. Back in 2012, some clerks charged $350, some charged $450. Now everyone, it's mandatory, shall charge $450, $350 plus $100. That's what it's going to cost your client to go through the new law. But what about if you have a client under the old law? This is issue spotting 101. This could be a great way for you to change a client's life. This would be a great way for you to, sir, what is your name with the sunglasses in front of the bright screen there? Richard. Richard, this would be, and you're a volunteer from what town? Centerville. This would be a great way for you to help a client be able to get a job. You back there in the orange, or no, not orange, it's, the light is odd. Go ahead, yes. Amanda. This could be a great way for you to help a client become eligible for housing. Russ, this would be a great way for you to help a student become eligible to become a nurse or a doctor or maybe even a lawyer. This could change a life. So let's look at some of the ways that you can quickly do some free expungements, and we'll just spin through these quickly. First of all, any questions, knowing that I'm armed with chocolate? Okay, I like that smile. Not you, but will you catch this for her and hand it to her because her hands are tied? Very good, thank you. What made you smile just then? Amusement? Chocolate, okay. Good answer. This goes to your cohort then. Okay. Good hands both times. Thank you. No fee expungement options. Okay. If you have been all the way through the criminal system and your charge was dismissed, you get an expungement. I'm seeing a smile of recognition. Charge dismissed, boom. But you have to ask, you have to apply. And where's the form? It's on the very, very back of your handouts. This is the simple one-page form. And Justice Clark, I love this. Once you get a good form, let's keep it. This is the Supreme Court's official form on their website, revised last in 2003. Hey, if it works, let's keep it. And it still works under the new law. So we're still using it. Yes, sir. Yes, great question. Would dismissed on cost? In other words, the DA offers something. Have you gotten a candy yet? There you go. Zale, who does some criminal law. If you have a client and the DA says, look, we're going to let you plead guilty and dismiss it on cost, your client pays the cost, yes, that is still a dismissal order that still qualifies for expungement, whether the state eats the fee or whether your client pays it. No true bill. Somebody says, hey, I'm going to go to General Sessions and roll the dice. I'm going to take a chance and bind it over to the grand jury. If the grand jury says no true bill, that can and should be expunged, and that expunges everything all the way down from the grand jury to General Sessions to the arrest records. Everything gets expunged. Judgment reversed on appeal. Who has ever taken a criminal judgment or seen one go up on appeal or read about it in law school? Oh, there, that gentleman. Yes, and that is Carlos. Thank you. I'm motion activated here. When you raised your hand, that helped. If a judgment is reversed on appeal, that becomes expungible. But you have to fill out the form. Noli prosequi, that ancient French Latin phrase, where the DA says, we're not going to prosecute this. Once that order goes down, once it's signed by the judge, announced by the DA and signed by the judge, that becomes expungible. Arrested and released without being charged happens in Gallatin, happens in Nashville, happens in Madison, happens in Knoxville. Arrested and released without being charged, that arrest record can and should be expunged. Get your clients the help they need to clean up their record if they're otherwise eligible. 2 civil expungements. What about, I have represented over 300 clients who were victims of domestic violence. And in Tennessee, 96% of our cases for domestic violence, women and children are the victims. That means 4% of the time that's men. There are some mean women out there. I quickly want to give credit where credit is due. But what I have seen some of these abusive men do is, it's a race to the courthouse. Once they know that they've been caught, they will go, make up a story, and file a false petition for order of protection against the victim, literally adding legal insult and sadly to injury. Once a hearing has been held, once that order of protection has been dismissed, then that's another expungible matter. Impossible to find because it's not in the index, it's nowhere else, but it is at Tennessee. The statute, actually, it's not in the domestic violence and order of protection statutes. It's at 363601 at SEC. Go to page 3, top of the page 3. It's deep in 40-32101A5. So if you need a cite for it, for your clerk to know that it's legal for an order of protection to be dismissed, which our clerk and master's office has had to have twice now to make sure it's really true, that's the action. Finally, every divorce case that I do, and I do a lot, about 65% of my practice is family law, I always ask the question, could this marriage be saved? Quite frankly, most of them say, I'm here talking to a lawyer. I've already gone through that. But I still want to ask the question because, and I let them know that reconciliation is a possibility. Counseling may help save a marriage. And where a couple go into divorce, where they don't consummate the divorce, where the divorce is not granted, if they decide to get back together again, that can be expunged. A divorce complaint can be dismissed. Another one where your clerk may need a statute. The clerk also gets a fee of $50 by statute, rarely done, but absolutely legal. And the Tennessee Attorney General opinion from 2006 says, here's what the clerk should do, just destroy everything you can that has anything to do with these parties' divorce. Juvenile matters. How many of you ever got in trouble, don't raise your hands, as a juvenile? I heard some knowing laughs at this table. I'm coming to this table. If you're a juvenile matter is private. It's confidential, and yet here in Sumner County and in Sumner County, you were laughing, weren't you?
No, I was laughing.
Thank you. Dawn was laughing. Chai was laughing at Dawn laughing. Okay. Juvenile matters also can and should be expunged either early on or when the client turns 18. Look at 5 quick answers. 4 of them apply only to juveniles. The 5th one, interesting, applies to young adults too. You may yourselves know someone who would apply on the 5th one. Quickly, we'll spin through them. Number 1, a child charged with a felony, what would have been a felony if they were an adult, and who's not adjudicated delinquent, can petition for destruction of their fingerprints, photographic records after they reach 18. Also, if a case was filed and then transferred over to juvenile case, say you had a 16 or 17-year-old and the judge decided to treat them as a juvenile, that can also be expunged, and the statutes are cited there. Go to page 4, top of page 4. What about just the general adjudication, where it's been through the system and the judge says, you know what, this child is not delinquent, we're not going to put that status on them. Right then, boom, that's basis for a petition for destruction of fingerprints and photographs. Finally, number 4, if a child reaches 18 and there's no record that he or she has been back in trouble since reaching 16 years of age, 2-year obeying the judge's orders to mind curfew, mind your parents, go to school, don't hang around with people who drink or use drugs, then the court shall, not may, shall grant a petition for destruction of fingerprints and photograph records. Now, go to the note right in the middle of page 4. This is a special law that I think is one of the most unknown, unused expungement laws in Tennessee. Juveniles get in trouble sometimes with the help of parents for early possession of liquor, beer. We had the case a couple of years ago in Hendersonville where a mother helpfully had a beer party for her daughter's 16-year-old birthday with about 30 kids there. So we had a big group of attorneys and 16-year-olds coming into juvenile court for that. But this also applies to young adults from 18 to 21, since the drinking age is 21. If a college student or a young adult gets charged with underage consumption, possession, or transport, that is automatically expungible when they get to, on the basis of them being under 21. So be aware, and all of these are zero fee. These could be issue spotting examples. Now, we talked about diversion. There's 2 types of diversion. There's pretrial diversion and there's judicial diversion. Pretrial diversion increasingly is being used only up at the criminal courts. The general sessions are mixed on how they're handling pretrial diversion. But that's where we're going to say we're not even requiring a plea to go down. We're basically going to put you over into probation, finish that, get everything met, and boom, you qualify for expungement once you pay your $450. So you avoid the hefty stigma in exchange for a hefty fee. That's how it works from the legislator's perspective. Go to page 5, judicial diversion. That is more formal. That's a conditional guilty plea that has to be approved not only by the defendant, but also by the prosecutor and the trial court at the time the guilty plea is entered. You can't go back after 30 days, 40 days later and say, oh, that would have been nice if I had pled guilty under judicial diversion instead of just standing and pleading guilty, as I see people do in general sessions all the time. If they only knew, if an attorney only would tell them, if the DA would tell them, they don't know and they don't get told. But if people know to ask for judicial diversion, and if they are otherwise eligible, this is a good way to unring the bell and keep them from going forward with a criminal record. We hope that they learn from that one criminal experience. There are a few, look at the middle of the page, few offenses that are automatically ineligible for diversion, including DUI, misdemeanor sexual offenses, conspiracy to commit a Class E sexual offense, criminal attempt to commit a Class E sexual felony offense, and solicitation to commit a Class D or Class E felony. Class E is the lowest. Class E misdemeanors, Class D coming up to Class A. Class A misdemeanors are the most serious. Then they flip over from 1129 to 1 year or more at Class E felonies and go up to Class A felonies, which are first-degree murder and other serious offenses. Class E felonies are the ones that have been added under the legislative new law. And Class E felonies are where we're going to go to on page 6. We're now moving beyond diversion. We're now moving into what happens when people just have a conviction. The problem is there's a bunch of hurdles here. I don't know that the legislature meant to put so many hurdles in, but they have a lot. Okay. Mary Clement, how many fingers on one hand? 5. Okay, that's the correct answer. That's your way to remember. It takes 5 years to qualify. 5 years of clean living, of crime-free citizenship before you qualify. That's one of the conditions. Another one is that you must have not been convicted of any other criminal offenses. And the third one, number C, you have to go through all the requirements, including paying fines, restitution to victims, which I actually like. That helps re-knit the fabric of society. Court costs and other assessments, completing any term of imprisonment or probation, meeting all of your conditions of supervised or unsupervised release, including picking up trash or whatever they want you to do. And if you were involved with controlled substances, you have to be drug-free, and they will test you for a full year. So which felonies are eligible for expungement? This is where you lawyers come in. The legislature wanted to make it easy. It is not easy. It is almost Byzantine. It is so complicated. Now, Byzantine is sort of a dark corner of our cultural reference. So I'm going to go back and take chocolates to this dark corner back there. I know you're there, and I think you unscrewed your light bulb so you wouldn't be lit up. Just think it'd be the right place at the right time. And you may think, have I just tarred you by reference just because of proximity to all these other dark-sitting people? Not really. I had a client who last week parked, Vicky. Where's Vicky again? Vicky. I had a client last week who parked in the handicap space right next to our chancellor. She forgot to put her placard up. You're supposed to take it off when you drive. She forgot to hang it back up. She got a parking ticket. She was coming to my office. She came out. She came back with her walker, and she said, I have just gotten cited. I said, it's not an arrest. You just have to show up for court. She said, I've had a crime-free life. Or at least they haven't caught me. And she's a retired teacher. She knows of what she speaks. I said, I tell you what, I will go with you right now to the Gallatin City Hall and see what can be done. We'll take your placard. We'll take your walker. She said, I'll drive you. And so we were walking to her car. I said, this is very bold of you. This is very nice. I said, but actually it's bold for me too because I'm walking out on the Gallatin Public Square with an accused criminal. She said, I'm the one whose reputation is in peril. Look at me walking with a lawyer here. So you all have already jeopardized your reputation back in that by sitting with the other 5 attorneys, each of you. Okay. So who's eligible? Class E is one of these weird laws that says it's a list of inclusion. So starting on page 6, going through page 7, and into page 8, you see the 38 laws, possibly 39 with drug fraud just around the corner if Governor Haslam signs it. 38 specific Class E felonies that are now expungible if someone's gone 5 years free, if they have no other crimes, if they've paid all their costs. They have to also apply. And here's how the form fills out. You fill out the form. It goes over to the DA. The DA sends it to the TBI, the clerk, and TBI and DBA have actually several days, 60 days, to try to act on it, but they try to act a lot quicker. And in a minute, I'll go ahead and tell you now, the TBI has an accelerated way if you are waiting for a job or waiting for an adoption or going back, look real quickly on page 13 to link this in if you have a visual memory like me, or if you're needing to get your carry permit. They will expedite your gun permit and expedite your expungement for fingerprinting, for job or carry permit, for firearms purchase, or for adoption. Otherwise, it's got to flow through the system and make sure. And that's a problem for the TBI. The TBI, just like all of you in this room, except they're paid to do what they do, and you all are volunteers who are going to be helping people in need, the TBI has to deal with imperfect records. Some of the clerk's offices in our counties, what county do you come from, sir? Williamson. Williamson County usually sends all of their records up to the TBI. Who's here from Carthage? Ah. Have you already gotten the candy? Oh, good. Carthage up in which county? Smith County doesn't always send their criminal records up to the TBI. So there's a little hole in the TBI records. So maybe it's expungible, maybe it's not. They always say, based on what's been reported to us, we think you're clear. Does it make sense to you so far? Yes. Good, thanks. So you've got your 38 crimes here. Go now to page 8. The crimes of exclusion list, if you will. Misdemeanors. All misdemeanors in Tennessee, all misdemeanor convictions can be expunged if you're otherwise eligible with 45 exceptions. So you remember for criminal law, for felonies, it was 38 in the list and everything else, too bad. For misdemeanors, it's 45 that are outside and everything else. So here are the ones that cannot be expunged. Starting with assault, aggravated assault of public employees, domestic assault, and ramps on up to a number of sexual offenses. Go to page 9. Reckless burning as opposed to careful burning. They are two different crimes. Careful burning, but without permit, is actually expungible. Aggravated criminal trespass of a habitation hospital or the campus of any public or private school or on railroad property. Going on down. Harboring or hiding a runaway child. Stalking, right in the middle of page 9. Stalking, amazingly low profile. It has to have would cause a reasonable person to feel stress or emotional concern. It has to be 2 or more times, and boom, that is a non-expungible offense, which is also grounds for the civil order protection. Methamphetamines, sale or loan to minors of harmful materials, possession of firearm after being convicted of a misdemeanor. Go to page 10. I'll let you all read down through that, but a lot of firearms, a lot of indecencies, disseminating smoking material, smoking paraphernalia to a minor after 3 prior convictions. So you can give a minor smoking paraphernalia. The first 3 strikes are free. It's that 4th strike that takes you out, not expungible. I think that's because we come from a tobacco-friendly state for the most part. Disorderly conduct at funerals. This is your chance to do some preventive law with some of your rowdier clients who sometimes imbibe to celebrate the loss of a loved one. And then, of course, DUI, the very last one. What else does expungement bring us? It brings us the right to reapply for voting rights. That's really important. That's really important in a civil society. And here in Tennessee, it also gives us that other equally, and according to the legislature, even more important thing, the right to apply for, carry, purchase, and do whatever you can do legally with a gun. And in fact, the legislature has expanded what can be done legally with a gun. Thank heavens they adjourned when they did. We'll stop there. But gun ownership privileges, I've told I don't know how many clients, I'm so sorry, your boyfriend has an order of protection. He won't be able to go hunting anymore. He's going to have to take up fishing. But now, if they've been convicted of one of these other things that are not assaults, they can get their carry permit. Gallatin, Tennessee is the headquarters, corporate headquarters, for those beautiful green trucks, the Serve Pro trucks. How many have seen the Serve Pro trucks? First 3, 1, okay. 2 tables up here, good. Serve Pro is a disaster restoration company. Their motto for extra credit is, like it never even happened. Now you'll see what I put on here is like it never happened, so I wouldn't be sued for trademark. I left out the even. You see how thinking like a lawyer. Okay, thank you, Mary Rose. Here's one for you. Okay. It is like it never even happened. That's the goal of expungement. In fact, our Supreme Court said in a famous case, it is as though you returned to the status you had before you were convicted. That applies for everyone except, I've just found out, the Tennessee Bar and the Board of Professional Responsibility. They have carefully reworked, have you seen this? Reworked their application. You all wouldn't have seen it because you're all licensed attorneys for the most part, except we do have one paralegal who's here. Can I have a hand for a paralegal who is here? Where's the paralegal? Upstairs now. You're challenging me. Okay. Okay. Thank you. Thank you. It's the missed throws that keep people alert, I find. Like it never even happened. The Tennessee Board of Professional Responsibility has artfully put in a question that says, have you ever, and we know you might have been expunged, but have you ever been convicted of a crime? Even if you've been expunged, you have to tell us. Now that's inconsistent with what our Supreme Court has said. Thank you very much.
That's the Supreme Court question and the Board of Law Examiners question. That's not
I beg your pardon. That's right. That's on the ethics. It's on the ethics application, is it not, Justice?
It's on the application.
It's on the application for license to practice.
But it is a question approved by the Supreme Court.
It is a question approved by the Supreme Court, and I think it's a darn good question now that I think about it. Some of us are more coachable than others. I had a client who has worked her way up from domestic violence victim to being falsely charged with a crime by her in-law mother who wanted to take her children away. We got her expunged. 10 minutes, thank you very much. And unfortunately, she also at one time bounced a check and pled guilty to it. It was needless, but it is now a crime. So we got it expunged, because it is one of the expungable offenses. And then she came to me, she said, Mr. Hawkins, she said, will this keep me from going to law school? I said, we like context. We like explanations. This is your chance to explain that you came up from poverty with your 4 children and that you finished college, you're now applying for law school. I don't think it'll stop. You don't think it'll stop either. Okay. How many thinks it will not stop her from going forward? Okay, yes. Okay, good. Tripp Hunt, coming to your table. Thank you, Mr. Tripp. And this gentleman, and you've already gotten one. Too bad. Sorry. There's a little bit of egalitarian streak here. But otherwise, other than applying for the bar, it is like it never happened. There are now some colleges I've seen who have started to add questions to their applications, like to certain universities. How many think that a client who is applying for a college or community college, if expunged, should be able to say, it didn't happen? But what if the application says, even expunged? Any advice here? Any information that you would give to your clients? What would you tell them?
If you apply to be a judge, it says even if it's expunged.
Yes, it does. And you've already gotten the candy, so you go, and you comes to you then. Thanks. Good. The answer is, thank you, Chai. The answer is disclose it, because honesty is the key. It can cause you to lose your admission. It can cause you to lose your student loan. It can cause you to lose your grant. Disclose it. Disclose it. So, but provide context. That's my thought. Do you agree, or what are your thoughts on that?
I agree.
Okay, yours?
Definitely agree.
No, I'm not looking for yeses. I'm looking, no's would have gotten you. I thought so. Okay, good. Let's go on to we're at page 11. Let's go to page 12. The District Attorney General's Conference has put out a handy little, they wanted to simplify it, so they put out a 7-step procedure for you to follow. I don't think it simplified it, but this is the official DAGC, District Attorney General's Conference, guidelines to completing the expungement process. So far, I have seen multiple expungements go through without following this process. Exactly. What people are doing, instead of applying first with the DA, they're applying with their local clerk. And they're paying their $450 fee, which, by the way, is non-refundable. Wow. That's where you can come in as a handy issue spotter. Use the old Davy Crockett motto. Davy Crockett, that famous Tennessean, his lifelong motto, I can see you all back there. His lifelong motto was, be sure you're right, then go ahead. That's what I want you to do with your expungement clients. Be sure you're right. If they are eligible, help them go forward. But by all means, check the law first before they blow and lose $450. Let's see. Would you, Mr. Steve, would you be so kind as to deliver chocolate to the very, very, very back pew, their table? Oh, no, you don't have to throw it. I can tell you're going to throw it. Okay, I'll take them. I saw the muscles in I saw his shoulder. It was going into the athletic pose. He was going to fling it to you guys.
Thank you. Thank you.
Oh, yes, thank you. Oh, my gosh, you're sitting back here.
Yes.
I didn't see you.
Is this adulterated candy?
Is this adulterating candy? Okay, for that question, you just got another one, and it goes to this table. They've gotten some. You all have gotten some. You're the good recipient.
Thank you.
Okay. This, I will just tell you, sir, be sure to take the foil off before you eat it. Then you'll be good. I'm coming to you. All right, now what questions do you have over here on the far left of the room, or as you see yourselves, the far right? You're far? Okay, that was the left-right question. That's adequate for candy purposes. Okay. Yes, sir. Which statute, Mike Pickering from Gallatin? 4035, 313. It does refer to a conditional plea.
What is the definition of conditional when somebody asks if you've been convicted of a crime? The condition being...
Our Supreme Court has given us guidance. The Supreme Court said in State v. Schindler, opinion holding, that we have two types of conviction in Tennessee. We have the general traditional sense of conviction, meaning that someone's guilty and they got in trouble and they got convicted. We have the technical sense. The technical sense is what is being referred to by the courts. Technical means the entry of a conviction and a judgment has gone down. So that's what's gone there. And a conditional judgment is not going to be a conditional, is not going to be a technical conviction unless the person who's going through diversion messes up. And then the judge will take that conditional guilty plea, strip them of their diversion status, put the conviction into force and effect, and they'll serve any remaining time that's required to be served.
Answer the question, Mom has a client who's been convicted of a crime with conditional status.
Again, if you've gone through diversion, you're asking
During the conversion, the conditional...
during the judicial diversion, can a person... No, they haven't been expunged yet. They must answer honestly if they're asked. They should say, I'm going through probation. Look, it's a case by case on what they're applying for. You look at the question carefully. If the application for housing says, have you been convicted? They could say no, because they technically haven't been convicted. Yes, sir, question.
I have consulted with someone who received judicial diversion from a matter about 23 years ago, and complied with it and got the matter expunged. The individual has a newer misdemeanor conviction after the first judicial diversion was completed and after the first expungement was entered. Is that person with a new misdemeanor conviction, which is not one of the 45 excluded matters that you've listed here, is that person entitled to apply for expungement a second time?
I will take you back to look at the bottom of page 12. Our new law applies to criminal convictions that took place November 1, 1989 or forward. Was this previous conviction, you said 23 years ago? That would have been since November 1, 1989. The answer to your question is no. They only get one expungement. You can't be restored to purity again and again and again. You only get one expungement by law. Okay. Last 1 minute. In the last 1 minute, I've saved a couple of incredibly important points. The one I've already told you, though, is you've got the form now. You've got the power. You've got the information. And tell your clients to keep their expungement order. Once they get their expungement, keep the order. They'll never be able to prove it otherwise. The clerk will be destroying everything, including the expungement order. You had a question, sir.
So does the DA get a chance to argue? Does the defense lawyer get a chance to come in and argue after you file the petition? Say it's somewhere in between the gray lines and you don't know. Is the DA the only one that will talk to the court as to whether this charge is now expungible?
The district attorney, once the application is made, will respond in writing as to yes, it's approved, or no, it's not. And if the answer is no, they must say why it's not. That must go back to the applicant, and then he or she has a chance to rebut that or to correct that. Does that make sense? Yes. Very good. excellent question. My time is up. Your lunchtime is here. I want to thank all of you again, not for being here, but for being volunteers, for what you're going to do after here. Thank you for your attention. And if you didn't get one of these Hershey's Kisses with almonds, I'm going to be up here for the next 5 minutes. Thank you very much.